Morning, everybody. We'll just take another minute or two for our presenters to get ready, and then we'll get started. Well, the doors are closed. It looks like we're ready to go. My name is Nathan Stewart. I'm from Ellis Don. It is my sincere pleasure today to introduce our session on construction law update. Our guest speakers today are Nadia Oche from Rasmussen Starretti and Megan Fougere with Norton Rose Fulbright. Please join me in extending a warm welcome to our presenters.
Some of you may know, I'm Nadia Oche with Rasmussen Starretti. Happy to be here with you today. I'm going to talk to you today about the changes to the adjudication under the Construction Act, and also how it interacts with the Federal Act. As some of you may know, the Federal Prompt Payment Act is in force. It applies to projects here in Ottawa. A lot of you do work on federal projects. And it's really important that you understand how the Federal Act and the Ontario Act apply to your projects, because unfortunately, for you GCs in the room, they both apply when you're dealing with the federal government. So, fun times for everyone. All right. And Megan will, when Megan is up here, she will give a presentation on the changes to the Act that came into effect as of January 1. And she'll talk about the transition provisions in terms of the provisions that apply now versus those that may apply later. So she will give you that in her Megan's presentation. Perfect. Okay. So we'll start first with the changes to the Construction Act. So the changes that came into effect as of Jan 1 for the Ontario Construction Act have had the effect of broadening the adjudication scope. So the matters that you can now bring to adjudication before ODAC have now been expanded. So under the old Act, and I'll call it the old Act, the primary focus of adjudication was really with respect to payment issues. Adjudicators under the old Act really didn't want to, and they were hesitant unless the parties agreed to deal with things like time extensions, was the GC or a sub entitled to time extension, scope issues, things like that. So under the new Act, those powers have now been broadened. So under the old Act, you had the valuation of services and materials which you could adjudicate. You had payment disputes, including change orders, notices of non-payment as to whether or not a notice was provided or whether the notice was valid, set-offs and holdback payment issues, and other matters if parties agreed. Now, under the new Act, those core payment issues are still part of the adjudication process, but now the parties can adjudicate things like scope of work determinations, contract price change requests, and time extension requests. Those were never previously part of matters that could be adjudicated as of right. If parties agreed to adjudicate those matters, they could, but it could not be forced. Now, if you're a sub, if you're a GC and you want to adjudicate that on Ontario projects, you can do so. Under the old Act, forcing consolidation was a right that was only afforded to GCs. So if a GC was involved in an adjudication involving an owner and a subcontractor, but two separate adjudications on the same issue, the GC could force the consolidation. Now that has been changed. Any party can require consolidation, as long as the adjudicator agrees. And so in order to consolidate adjudications, they have to relate to the same matter. So you can't have a dispute between sub and GC with respect to change order 1, 2, 3, 4, and then a dispute between GC and the owner with respect to an extension of time that has nothing to do with that change order. That won't be consolidated because one doesn't impact the other. It's really where you've got an issue where both adjudications are related and the outcome of one is going to impact the outcome of the other. Just to give you a brief overview of how this works, the party who wants to consolidate has to give written notice that they wish to consolidate, and that notice has to be given no later than the 5th day after the adjudicator receives the documents from the claimant. So those documents being the contract and any other document that they're going to rely on for the adjudication. The Act also sets out the other matters that have to be outlined in that notice. But essentially, provided that the adjudicator agrees that they should be consolidated, so if the adjudicator agrees, yeah, these two matters are related, and the outcome of one will have an impact on the other, then the matter will be consolidated, regardless of whether it's the sub that asked for it, the owner, the GC, it doesn't matter, they'll be consolidated. And I should mention, just for timing purposes, because my presentation and Megan's, any questions we'll deal with at the end. So if you have any questions arising from my presentation, please hold off at the end and we'll make sure to try and leave some time so that we can answer any questions that you may have. All right, under the old Act, you had to commence your adjudication prior to completion of the contract, which was super problematic because if the contract was completed and the holdback hadn't been paid, and the notice of non-payment hadn't been provided for that holdback, you're out of time. You can't adjudicate. The Act has been changed now. You have 90 days. So I'm going to talk first about the GC. For the general contractor, you have 90 days from completion, termination, or abandonment to commence your adjudication. For a subcontractor, it's just like when you're putting a lien on, it's 90 days from the earlier of completion, termination, abandonment of the GC's contract or your last date of supply. So if you're a subcontractor, you have to make sure that if you're done and that prime contract hasn't been completed, but you have an issue that you wish to adjudicate as between you and the general contractor, you have to start that adjudication within 90 days of your last date of supply if you're done before the contract is complete. I'm going to use the easiest example. If you are the footings and foundation contractor and you're going to be done long before that project is done, if you have an issue that you need to adjudicate or that you want to adjudicate, you must commence it 90 days before 90 days expires from your last date of supply. So if you're a sub, you have to keep track of 2 time periods. It's either your last date of supply or completion. So if you're one of the finishing trades, you're one of the last guys out, you're the HVAC guy, you're the electrical fire alarm, you're probably fine to go on 90 days from completion because you're there up until the end. But if you're at the beginning, keep track of your time frame to commence your adjudication. The deadline can be extended, but both parties have to agree. So if you're the sub and you didn't start your adjudication and you say to the general contractor, look, Can we adjudicate this issue? And the general contractor says no, then you can't force it. You're out of time. Your only option at that point will be commencing an action in court. Under the Act, now you can use a private adjudicator. You don't have to use the adjudicators on the registry. However, there are qualifications that the adjudicator must meet. They have to have 10 years of relevant construction experience. That doesn't mean it has to be a construction lawyer. It can be an engineer, an architect, a PM. As long as they have 10 years of relevant experience in the construction industry, they can be a private adjudicator. They have to be approved by ODAC. They can't be an undischarged bankrupt. They can't have any indictable offense convictions. Also, they must charge a minimum fee of $1,000 per hour. So yes, you can use a private adjudicator, but there's a cost to that. If you have an adjudication that is, you're having a dispute over $4 million, maybe you want to have a private adjudicator. It may make financial sense. If you're dealing with a $50,000 issue, it doesn't make sense to use a private adjudicator. Adjudicators on the registry, their fees range from $300 an hour to $800 an hour, depends on who you're picking. So these are things that, yes, you can do it, but think about, does it make financial sense to use a private adjudicator? Because it's a minimum fee of $1,000 per hour. And if you're going to use a private adjudicator, you must set out the agreement in writing. The agreement has to set out the process for the adjudication, how is it going to proceed, and the agreed upon fee. That will have to be submitted to ODAC so that they can confirm that they're charging $1,000 an hour. All right, so those are high level the changes to the Ontario adjudication process. Much of the remainder of it, for those of you who've been through adjudication, remains the same. Timing for delivery of your documents, timing for the decision, all of that essentially remains the same. Now we get to, what do you do on a federal project? We all know in Ottawa, lots of federal projects coming down the pipeline. The Federal Prompt Payment Act applies to projects in Ontario. However, the Act also provides that Ontario is a designated province. Ontario is a designated province because we already have our own prompt payment and adjudication provisions. By making Ontario a designated province, that means the provisions that apply, so when you look at the Federal Act, there are provisions for payment from Canada to the general contractor, payment from general contractor to sub, payment from sub to sub-sub and suppliers. The provisions that deal with the relationship between general contractor and sub and sub-sub, those don't apply on Ontario projects. What's left is the Federal Act will apply to the relationship between Canada and the general contractor, and the Ontario Act will apply to the relationship between the general contractor and the subcontractors and the subcontractors and the sub-subs. Still no lien rights. You still can't register a lien. So the Ontario Act, in terms of how it applies, the prompt payment provisions apply, adjudication applies, and holdback. Those are the provisions, and the trust provisions apply as well. But in terms of, for the purposes of today, adjudication, prompt payment, and holdback as between GC and sub under the Ontario Act is what governs that relationship on federal projects. This becomes problematic because Ontario has made a number of changes that aren't reflected in the Federal Act. So, how do we deal with that? Things you need to know. As we talked about, under the Ontario Act, notice of adjudication within 90 days, documents within 5 days, determination usually about 30 days, go more on 45 to 50 days for determination, payments are due 15 days. That's under the Ontario Act. Under the Federal Act, same as with the Ontario the proper invoice, so the invoice from the general contractor to Canada triggers your federal deadlines. Payments are due in 28 working days. Very important, because under the Ontario Act, payment is due in 28 calendar days. What does 28 working days mean for the federal government? We'll get to that in a minute, because depending on the time of year, it's pretty long. Adjudication can be commenced within 21 calendar days, because it's not all the same. Some timelines under the Federal Act are working and some are calendar. Adjudication can be commenced within 21 calendar days of non-payment. Determination is within 20 working days after the day on which the response from the respondent has been received by the adjudicator. That determination date can be extended by 5 working days. And then payment of a determination is due in 10 calendar days. Meaning of working day under the Federal Act. Excluded, Saturdays and Sundays. Federal statutory holidays. The period from December 24th to January 1st. That's all excluded. And that's really important when you're rendering an invoice at the end of November or December. Also excluded is but this doesn't apply to Ontario projects, is the 2-week period, the construction holiday in Quebec, but that doesn't apply here because we're not talking about projects in Quebec. So, the timelines that are calculated in working days. 28 working days for payment of a proper invoice. 21 working days for notice of non-payment. 5 working days for the claimant's adjudication materials. And because the government has assumed that claimant will generally be the general contractor and respondent will be the government, they've given themselves 20 working days in which to respond to your notice of adjudication. This is what's really important. When you're under the Federal Act, you're counting in working days. When you're under the Ontario Act, you're counting in calendar days. Thankfully, under the Ontario Act, a contractor has to pay their sub 7 calendar days after they've received the money from the owner, thankfully. But that means you need to make sure as a GC, and the subs need to bear in mind, when you're on a federal project, don't expect payment on the 35th day after the GC has delivered their proper invoice, because they're not getting paid within 28 calendar days. They're being paid within 28 working days. However, as the GC, once you are receiving those funds, you have 7 calendar days in which to pay your subs. And then the trickle down goes from there. If you're a sub, you have 7 calendar days in which to pay your sub-subs and your suppliers. All right, so just to do an overview, and then I'll give you an example of what you're looking at when you're looking at the working day, especially if you're invoicing at the end of the calendar year. So in Ontario, invoice is issued 28 calendar days for payment, plus another 7 calendar days to pay the subcontractors. Under the Federal Act, proper invoice, and again, they've got the definition of proper invoice, just as in the Ontario Act. And it's a similar definition. You've got 28 working days, excluding the weekends, holidays, December 24th to January 1st. Once the contractor receives payment, 7 calendar days to pay their subs. So here's an example. You issue your proper invoice November 30th to the federal government. They have 28 working days. Now you have to exclude weekends, December 24th and January 1st. That actually takes you to January 18th, which is a really long period of time. When you are used to getting paid 28 calendar days, your subs are used to being paid 35 calendar days. January 18th, you're going to get that payment from the government, and then you have 7 calendar days in which to pay your sub. Here's where it gets even more problematic. Under the Ontario Act now, we've got expanded adjudication rates, which means a sub on a federal project can legitimately bring an adjudication for an extension of time. They can bring an adjudication for a determination on scope. Under the Federal Act, you are limited to payment issues. A GC can only adjudicate payment issues with the federal government, which means if a sub has taken you to ODAC on an extension of time, and you don't get that extension of time from the federal government, you're now in a situation where your sub has been granted an extension of time under ODAC, and you can't get the same thing under Canada. So this is problematic. Obviously, these decisions under ODAC and CANDAC are all interim. You can litigate them before the courts later on, but you could find yourself in a situation where, as a GC, you have a determination against you that you can't get a reciprocal one from the federal government. And you can't contract out of the Act. So you can't put provisions in your contract saying, sub, you can only adjudicate these matters. If it is a matter that is prescribed under the Act, you can't eliminate them. So this does become a problem now that Ontario has made these changes. I don't know whether the federal government will amend their act to bring that in. They may, let's hope they do. Because it's a problem for Ontario, it's a problem for Alberta, and I think Manitoba is the other one who's a designated province. So these are things that you do need to bear in mind on these federal government projects. So risks for the contractors, primarily the general contractors, but also the subs, miscounting working days versus calendar days, assuming that you're going to be paid faster than you are, and then cash flow strain on these extended periods when you're dealing with that time frame between Christmas and New Year's where you're not being paid till January 18th. Or if you've rendered an invoice on December 24th, now you're not getting paid until February. So these are things that you need to bear in mind and prepare yourself for, because this is the reality when you're dealing on federal projects. Just as with the Ontario Act, interest is applicable on determinations under the Federal Act. So if you haven't been paid, the government will have to pay you interest. But as a GC, you do need to take into account what provisions do I have to maybe add to my contracts with my subs to, one, make sure I'm still staying within the confines of the Ontario Act, but to better signal to the subs what the timing provision is going to be on the payments, so that they have an understanding, especially some subs who've never been on a federal project. Obviously subs that have worked on federal projects, they may be used to it, but if you've got a sub who's never worked on a federal project, having supplementary general conditions that highlight to them that they won't be paid until 7 days after you've been paid, but you're not being paid until 28 working days after your proper invoice, and maybe putting in that definition of working days, so that your sub has proper notice, and they're not going to be harassing you saying, you haven't paid, and then they commence an adjudication. Their adjudication wouldn't be valid because the payment wasn't due, but it's just more administrative work, it's more work on your part. So those are things to bear in mind in terms of how to try and deal with these things and navigate these differences. I think I've hammered this enough in terms of you've got on the federal projects, payment-only adjudications, the GCs, those of you who are in the room, you guys are meat in the sandwich, you're stuck in the middle, because the subcontractors, they can bring an adjudication on any issue that is allowed under the Act. As we talked about, pay when paid provisions, obviously that are in keeping with the terms of the Act. Ensuring that your contracts provide for notice of non-payment language that fits with both regimes, flow down the adjudication and notice obligations clearly so that your subs understand. Don't start a notice of adjudication on day 36 because you didn't get paid in 35 calendar days on a federal project, because your adjudication won't be valid. And then, again, just making it clear to subs what those interim payment risks are with respect to timelines and change order clauses and whatnot. As we've talked about, track your deadlines. If you need to have 2 clocks running on a federal project, then do so. Make sure that you are keeping track of your working days versus calendar days on the federal projects, because that's where you're going to run into problems. Because as a GC, if you start an adjudication for non-payment, but you've done it 28 calendar days, the adjudicator is going to dismiss your adjudication because payment wasn't due at the time that you started your adjudication. So you got to keep track of those things. Thankfully, hold back 60 calendar days. You're not dealing, because the act, the way it's written, it's the holdback provisions of the provincial act that apply. So you're dealing with 60 calendar days, not 60 working days. So that, thankfully, is not extending your time frame in terms of receipt of payment of the holdback and payment out to your subs. The provisions of the Ontario Act, which Megan will touch on because they have changed, those would apply today on federal projects. So the holdback provisions that apply today apply to the federal projects. So annual release of holdback, subject to the transition provisions, which Megan will explain, the 60-day, payment within 61 to 74 days, that applies to the federal act, and it's calendar days. So I'm going to turn it over to Megan, and then once Megan's presentation's over, we'll take any questions that you may have. All right.
Got a minute or two if anyone has any burning adjudication. Want to ask now?
When we have those every couple of years, federal workers strike, does that affect working days?
No, strikes are not part of the working days. So it's just it's Saturdays, Sundays, federal holidays. So that includes the National Day of Reconciliation on September 30th, Remembrance Day, which for Ontario, that's not a holiday for the private sector, but that's a holiday. Easter Monday, Good Friday. So all of those, plus the December 24th to January 1 date. Yeah.
If the GC doesn't submit his invoice to the government on a federal job, does that affect the subs timelines?
Yes, the subs timelines are dictated by the date of submission of the GC's invoice to the federal government. And that is true whether it's a government job or a private job. The GC's submission of their invoice to the owner is what starts the clock for all prompt payment.
I've had a case where the GC purposely didn't invoice the client for 8 or 10 months by himself time because he couldn't afford to pay the backlog and suing the government the client.
Mm-hmm.
So you're still stuck there.
You're still stuck there. Just because I can't figure out this trackpad. Let's see. Fingers crossed. There we go. So it's up here. To go left and right? Yes.
Wait, left is right?
No, so. So when you're here, and then advance.
Okay, you leave it there.
There? Okay.
Okay,
All right.
good morning, everyone. Thanks, Nadia. You'll see we are doing this in a bit reverse order from what we originally planned. I'm talking to you about the Construction Act changes, and Nadia's gone through the changes to ODAC and how they interact with the federal scheme. Okay, so probably a few of you have already heard about some of the changes that came in on January 1st, or maybe have attended education sessions already. So this will be a bit of a refresher for some, but maybe a chance also to ask questions that you might be thinking of now that you're seeing this in practice a little bit. And one of the things I'm going to talk to you about this morning, as Nadia mentioned, are the transition provisions, which deal with how, like, we're basically telling you how you know which version of the Construction Act applies. You might wonder why you care about that. It's very lawyerly and technical, but you should care because number one, it impacts how your adjudications might look, as Nadia just talked to you about. And one of the key things that you should care about is that it determines, the transition rules determine whether or not annual holdback release is mandatory on your projects. So if you're the one waiting for a holdback, you probably want to know if that is something applicable to your contract, or if you're situated in the pyramid such that you'd rather hold on to the holdback for a while and maybe earn interest on it, you'd like to know if you can escape that annual mandatory requirement for a little while. It's also important because we lawyers who draft the legislation have made things really confusing with how we've rolled out changes to the legislation over the years, because we now have 3 versions of the Construction Act, or the former Construction Lien Act, in play. I say 3, but really it's actually kind of 4. So we have the old Construction Lien Act from way back when, pre-2018. This is when you had 45 days to register a lien, and before we had the first round of overhaul changes to the Construction Act of 2018. This is falling away. It really is only in play in some really old legacy projects, the big, P3 infrastructure projects that have been in construction for several years, almost over a decade at this point. Then we have the pre-January 1, 2026 version, which is basically the 2018 to now version, and that's where there's 2 sort of subsets. If you remember, we made the changes in 2018-19 in a phased way. So first, the changes to some of the basic things like lien deadlines came in 2018. That's when you went from 45 days to 60. That's the biggest change most people will remember from that time period. And then it wasn't until 2019 that adjudication and prompt payment first came in. And so there were kind of 2 versions of the act that were in play up until now on most projects. For anything procured after 2019, October 1, 2019, you're under what the version of the act was up until the calendar rolled over to this year, where you had prompt payment, adjudication, and all the other prior changes to the act, like your 60-day timelines. And now we have the current version of the Construction Act, which, as I've said, came into force on January 1st, 2026. These are changes that the government was sort of flagging, rolling out for a while, and it took a while for them to come into force, in part because there was some consultation with industry stakeholders, lawyers, about sort of initial proposed changes and how they might work, and some things that people got a bit up in arms about. And so some changes were made from the time they first planned this rollout of changes to when they actually came into force on January 1. And as I mentioned, the new provisions, the new version of the legislation contains some rules for how you determine which of these 3 or 4 different versions of the legislation apply to your project. Some of you, if you've registered a lien in the last couple of years, probably know that the 2018-2019 changes, the key sort of indicator as to whether you were under the really old version of the Act, your 45-day lien timeline, or the 60-day timeline of the Act, or if you had access to prompt payment and adjudication at all. The determining factor was when the procurement process for that particular project began. So if you went to register a lien in 2020, your lawyer probably asked you, hey, when did the procurement process for this project start? And if you're a subcontractor, you may very well not have known, and that's where us lawyers had a lot of fun over those years, trying to figure out exactly which version of the Act applied, or arguing on either side to say it should be one or the other. The new rules have tried to simplify things a little bit by taking the position that the current law applies to your contract as of January 1st, 2026. So January 1st, 2026 rolls over. Don't worry about this procurement process thing. That was confusing for a lot of people. The new changes, we're going to make the trigger date January 1 calendar year rollover for contracts that are both in place and commencing after January 1st. But of course, we made a bunch of exceptions to that for how it's going to actually work in practice. Now, I'll show you what that looks like, which fun even for the lawyers to have to read through. But it's actually somewhat straightforward in practice, so I'm not going to take you through each of these 7 different subsections of the transition provisions that we now have, but try to go through it practically, to go through a couple of examples based on actual contract date as to which version of the Act is going to apply. So as I've already said, contracts in play now, but the simplest version to figure out what applies is contracts signed after January 1st, 2026. So signed, again, procurement process not relevant, for anything signed, entered into after January 1st, 2026. All of the new rules apply right away, including the annual holdback release requirements, which I'm going to talk to you about a little bit. And we'll talk again about that, but the annual holdback process starts on the first anniversary of the contract date. So that's the simplest version of how you figure out what version of the Act you're under. And then, as I mentioned, there's still bucket 2, which is some of the legacy projects that the old Construction Lien Act still applies to. Again, really only affects a handful of large infrastructure projects, long-running projects, and this will fall away very soon. Then we have contracts that are procured, not entered into, but procured between July 1st, 2018 and October 1st, 2019. And so these are the projects where you have 60-day lien timelines because the 2018 changes are in effect, but you don't have access to prompt payment and adjudication because that didn't come in until 2019. So again, probably a smaller subset of projects, but still some that are out there. Note here though that even these projects that are between 2018 and 2019 have some of the new rules that apply. So the pre-2018 stuff, you're under the old Act for all purposes. From 2018 to 2019, you're under the new Act, so the new rules apply, but you still don't have prompt payment and adjudication because you didn't have it to begin with, so you don't have it now that we're under the 2026 version of the legislation. Annual holdback release will apply, but it gets sort of phased in, and we'll talk about that when we get there. So pre-2018, old version of the Act, 2018 to 2019, and in fact, also 2018 or 2019 to 2026. So everything up until the contract calendar year rolled over, pardon me. The current version of the law applies, but annual holdback release doesn't apply immediately, and there's some notice of termination rules that are changing as well in 2026 that are a bit more detailed than they used to be, and the old rules for notices of termination still apply under these pre-2026 contracts. So the distinction there is that 2018 to 2019, you get access to the new version of the Act for holdback purposes, but not prompt payment and adjudication because you didn't have it to begin with. But for everything that came into force, this is a typo, it should say October 1st, 2019 there. For everything that was governed by prompt payment and adjudication previously, you still have all that, but you're under the new rules, you just have a delayed implementation of the new holdback requirements. Lastly, for P3 arrangements, project agreements, there's a specific definition of what those are in the Act that I won't spend time on today. But for those particular types of projects, for anything signed before January 1st, 2026, after that, the new rules apply. But for anything entered into prior, the holdback release rules do not apply at all. They don't get phased in, they just don't apply. But all the other new rules do apply. So it's still a bit confusing, but less confusing than it's actually written in the legislation. The important thing to know is that for most projects, the new rules apply. If you're unsure, that's when you really have to pay attention to this. So if your contract signed up this year, you're under the new version of the legislation, or the current version, I should say. If you're one of these ones on the fence, it gets a little sticky, but really the main difference is whether you have access to annual holdback release or not. Are there any questions on that before I move on? It's
I got one quick one. What governs the anniversary date of the old act release? The prime contract or the subcontract?
when we're talking about the procurement process is the trigger.
When the yearly release is applied to the...
Oh, for the annual holdback release.
Correct.
Yeah, so we'll be moving on to that in just a moment, but it again depends on which version you're under. You're right, you said there's an old version and the current version, and there's different rules for what is the trigger date for holdback release under both sets. Anything else on the
This
transition?
is like all prime contracts though, right? Like, contract that.
Yeah, so previously when we're talking about the procurement process that was entered into, we're talking about the prime contract, which was always fun for subcontractors because you don't know when the RFP or the RFQ went out for that project necessarily. But here we're now talking about when the contract was actually entered into, but we're talking about the prime contract. That's a good question. Okay. On to annual holdback release. So this isn't totally new. This did exist under the prior post-2018-2019 version of the legislation, but it was permissive. It wasn't mandatory. The parties could agree to have this in their contract, being the prime contract, but it was only allowed in certain circumstances. So the contract actually had to say that annual holdback release applied or phased holdback was another option you could access. So the prime contract had to say that. Contractor might ask for it, owner might say no. It was a topic of negotiation and supplementary conditions for a couple of years. But also the project had to meet certain dollar thresholds, which were quite high. Those were prescribed by regulations. They're in the millions. Was it 20 million threshold, I think? Anyway, it was only applied to a couple of projects. Now it's mandatory for all projects that the legislation applies to, whether or not the contract says it. And you can't draft a contract that says we're not going to have annual holdback release. Like with everything else under the Construction Act, you can't contract out of it. If you try to, it's not applicable. A court won't enforce it. So now owners must release the accrued holdback annually on all contracts that it applies to. And how does this work? First of all, there's a new notice to be published. We added a lot of notices with the 2018 and 2019 changes, and now there's more. So within 14 days of what that trigger date is, and to the earlier question, for contracts that are entered into after Jan 1, 2026, your anniversary date is just the date that the contract is entered into. Probably there's going to be some lawyers that end up fighting about what it means to say the contract was entered into. Is it signed? Is it the date that the price is accepted? Is it the date that we agree on supplementary conditions? The Act doesn't give a lot of guidance on that, but hopefully it'll be, in most cases, probably whatever the effective date of your contract is, which often is written like in the CCDC form. There's a spot to write that. So 1 year after that is the deadline for the first annual holdback release on that contract. And within 14 days of that date, the owner has to publish a notice of annual holdback release in the Daily Commercial News, Link to Build, wherever they publish their other notices or certificates on the project. And then after publishing the notice, assuming no liens go on title, so same rules as before, where if a lien is registered on title, you cannot release the holdback. The owner or the GC has to bond. The owner has to deal with it, or the GC has to bond off the lien in order to get holdback released. But assuming no liens go on within that, so publication 14 days after the trigger date, and then 60 to 74 days after publication, assuming no liens, is when the holdback has to be released. So it's a minimum of 60 days after publication, which is to make sure there's no liens that are going to go on title that are claiming against that holdback. So they cannot release until 60 days. They must release by day 74 after publication. So there's a 14-day window after they can release to the point where they must release. And again, if a lien goes on in that time period while they're waiting for the clock to run in order to release holdback, then they have to deal with it as you would at the end of a project where a lien goes on and holdback comes due, which means someone has to bond it off or settle it or take care of it by other means. And then this works downstream as well. So once contractors receive their annual release of holdback, they have to flow it down to their subs within 14 days. And then same 14-day timeline applies down the pyramid. A couple of changes, I don't know why that slide got jammed at the top. A couple of changes from the previous version. For annual holdback release and holdback generally under the 2018 to 2026 version, you could publish a notice of non-payment of holdback. So some of the prompt payment notices that came in where an owner can publish within 14 days of receiving a proper invoice, an owner could publish a notice of non-payment to say, we're not paying this, or we're not paying part of this, and here are the reasons why, and then you could adjudicate that. There was a notice of non-payment of holdback, so when the owner receives the holdback invoice from the contractor, they could say, we're not paying all of this, we're not paying part of it because of XYZ reason, incomplete work, deficiencies, and then that could be disputed. There is no longer any form called a notice of non-payment of holdback in the legislation. So owners can no longer hold back from the holdback to cover off deficiencies. They can set off against the holdback only if a contract has been terminated or abandoned. So basically, if we're just talking about holdback at the end of a project, that there isn't a big fight that has resulted in a termination, or the contractor has abandoned the project for some reason, circumstances where the owner has to go and finish the project on their own or hire someone else to do it. Absent those circumstances, they cannot set off against the holdback. It must be released without set off. But if there's a termination, or if there's abandonment, which is like a legal term that it's a gray area as to what constitutes abandonment, only then can the owner set off against the holdback, and only then after lien periods have expired. So they have to make sure no subcontractors are claiming against that holdback by registering a lien on title before they can start setting off their completion costs. One thing to clarify is that lien rights do not expire annually. And so this is the thing that got lawyers and probably our insurers up in arms when the first version of the new legislation came out, was originally lien rights were going to expire along the annual anniversary date. So for the holdback release, which would have been a mess to figure out how lien periods work on contracts, so they got rid of that, thankfully. Your lien periods all still start to run at nearing the end of the project or whatever your previous trigger dates were. So publication of the certificate of substantial performance at the end of the project, if you're a sub, your last day of work, contract termination or abandonment or completion, all of the other lien deadlines remain the same. They don't start to run on those annual anniversary dates, thankfully. One question I've been thinking about, and I've talked about with other construction lien lawyers, is that, like, how effective is your lien rights at the end of a project then? If the holdback, if it's a multi-year project and your holdback's been released every year, as it should be, liens are ultimately a claim against the holdback. So you register a lien on title to the owner's premises. If they post the holdback and say, okay, fight about it, then that's your leverage against the owner is gone. They've posted the holdback. If the holdback is diminishing over time, or for example, on a project where you can't register on title, like it's a municipal project and you can only deliver a written notice of lien, which is a claim against the holdback only, what leverage or what weight do your lien rights have at the end of the project if the holdback has been released annually over time? It just means a much smaller pool for people to claim against. Doesn't mean liens are going to be worthless, and obviously larger projects are going to have much very holdback left over at the end of the project, even if it's been released annually. But that's one question I've been thinking about. should say you can still lien during that time period of annual holdback release. Your lien rights just don't expire. So if you see that the notice of annual holdback release has been published and you're a sub and you haven't really been paid up to date and you're worried that if that holdback gets released, it's not gonna flow down to you, you can still register a lien, and that'll come with all the business considerations that registering a lien normally would. Is this gonna stop the flow of funds? You know, what leverage does this get me? How's this gonna play out? But you can still do it. Your rights to do so just don't expire or risk expiring until the normal triggers. There were a few other technical changes that have come in. I won't spend much time on this. One thing that's helpful for contractors is that there's now a deeming provision for proper invoices. So in the early years, first years of adjudication, we lawyers spent a lot of time fighting about what counts as a proper invoice, because a contractor would adjudicate and say my invoice was proper, it wasn't paid. Owner would say, sometimes thinking about it for the first time, would say this is not a proper invoice and that's why I didn't pay, and we got into a lot of sort of jurisdictional disputes, and a lot of ink was spilled by lawyers in adjudications fighting about whether an invoice is proper or not. Now, once you deliver your invoice, you still should try and need to try to meet the requirements of what the definition of a proper invoice is. But if you submit your invoice and the owner does not dispute that it's proper within 7 days, then it's deemed to be proper. They can't then on day 10 come back and say this invoice is not proper. And it's, once, if they tell you within 7 days, then you just resubmit your invoice, and that's why that timeline's short, so they can't wait until day 28 and say, I'm not paying you because this invoice isn't proper. One little change that's helpful for lawyers is just you can now join a lien claim and a breach of trust claim. It was muddy whether you could before. They flip-flopped a little bit on whether you could when the changes to the prior versions came in, but now you can, it's clear. This is just helpful because if you register a lien, you get to the point, the lien doesn't get you paid, your lawyer has to perfect that lien, but you also want to make a breach of trust claim under the Act, which is a separate remedy. You can now join both together in the statement of claim, so you're paying your lawyer to do one statement of claim and not two. And something helpful for the architects and engineers is that there's now a presumption that design services are lienable, that they've added value to the property when the owner has actually retained holdback. So under the previous version of the Act, whether architects, engineers, design professionals have lien rights depended on whether their work improved the value of the premises for the owner. And that's sort of a sliding scale, like early concept drawings, maybe not lienable, but if the drawings actually get you a building permit or get you site plan application approval, then that's value added. That increases the value of the premises if the owner goes to sell the property. And so the work that design professional did to prepare those drawings is now lienable. Now, if the owner treats the project or the contract with the design professional as if the Construction Act applies, so if the owner's withholding 10% from the architect's invoices, meaning the owner thinks the Construction Act applies to that contract, then it's assumed that they have lien rights as well. There's a presumption in place that the architect can lien, which just makes sense. Lastly, and very quickly, I mentioned that there's new notice of termination requirements. There were notice of termination requirements under the previous version of the Act, but they've changed. Now, if an owner or a contractor or anyone whose lien rights could be affected, because termination is a trigger for lien rights, terminates a contract, they must publish a notice of termination. Again, that has to be done on the Daily Commercial News or Link to Build. And they have to do that within 7 days of termination. So if the owner terminates the GC for any reason, they send a letter and say your contract is now terminated. Within 7 days of giving effect to the termination, they have to publish that notice. And the date of publication is deemed to be the date of termination for lien rights purposes. And this is important because termination is one of the triggers for when your 60-day lien period expires. And that could result in a lot of disputes as to when is the effective date of termination. Is it the date that the owner tells you in a site meeting your contract's being terminated? Is it the date that the owner's lawyer sends you a grumpy letter saying you're in default, your contract is going to be terminated if you don't remedy this in 7 days? If you don't respond to the letter in 7 days, is the date of termination that 7th day where they said do something or else? Or is it the day you get an actual notice that says now you're terminated? Obviously that would make things very difficult for parties to determine when their lien rights start to run if termination is a proper trigger. So now it's deemed to be the date that the notice is published. And that also gives notice to the world or notice to subcontractors that, hey, the prime contract's being terminated, I need to get any liens in order if I think I have to lien. So one practical takeaway from this is that in the same way you've monitored or had someone monitor the DCN or link to build for certificates of substantial performance, especially if you know there might be something brewing at the top, you should be looking for notices of termination as well, because that could trigger your lien rights as a subcontractor. So again, maybe you don't always know if there's a dispute brewing between the owner, but whatever regular checks you do to look for certificates of substantial performance on a project, you should also be keeping your eye out for notices of termination. And what does it mean if the notice is not published? Well, it doesn't mean that the contract's not terminated, but the project is exposed to liens longer. So if I'm the owner terminating a contract, I want to get that published because I want to know that the lien clock has started to run for the subcontractors under the GC that I'm terminating. If they don't publish it, then absent some of the other lien triggers happening, like abandonment or publication of a certificate of substantial performance, then that lien period might not start to run for everybody on the project. And as I mentioned, you should now be looking out for these things. Lastly, I forgot to mention from the previous slide that it doesn't mean you can't challenge the termination. If the owner publishes a notice of termination of your contract, you can still dispute it, you can still sue them, you can still register a lien, you have all of those rights. It doesn't stop you from challenging the termination. That's what I wanted to cover. It's a lot of information we've downloaded, yeah?
On the topic of proper invoice, and if I have a payment certifier on the owner's side, does that 7-day notice cover that their review process as well, or is it just the owner's notice for them to tell me if the invoice is improper or not?
That's a good question. So under the previous legislation and still today, whether an invoice is proper or not cannot depend on whether the consultant says so. It can't depend on a certification process being completed. So really it's on owners to push their consultants to tell them if this is proper or not. I mean, whether it's proper you don't need a consultant to do that. It's like, does it have the date? Does it have the contract number? Did they say what services they're billing for? They're pretty basic requirements to be met, and it could also be anything that the contract says you have to include. So if the contract says you have to include your WSIB clearance certificate and you don't, then that's technically not a proper invoice. But yeah, so really it's on the owner to go through the checklist within the first 7 days, and then they still have 14 days to publish the regular notice of non-payment. We just don't have the notice of non-payment of holdback anymore. So they have 14 days for their consultant to tell them, no, they billed 100%, they're actually at 80%, but they have 7 days to look at the checklist to make sure the invoice meets the requirements. And if the owner thinks they need the consultant to tell them if the invoice is proper or not, they have to get the consultant to do that within 7 days. Yeah?
For smaller sized projects that span probably 2 to 3 months, does the annual rollback release also apply, or is it still 60 days?
No, it'll just be, that's a good question. Anything within 1 year is just gonna have your regular holdback rules apply. It's only things that run longer than a year.
Any other questions?
For the annual release of holdback, what would that process look like for like a subtrade, right? Because like the holdback would presumably the owner would publish it, right, the annual, and then it would be the GC that would then kind of apply for the holdback, I guess, kind of for the entire project, and then pay that to the subs. So like I guess as a subcontractor, are you waiting, I guess, for the general to tell you, or are you trying to initiate something? Because the problems that we're running into more and more is like the general contractors are using like technology to enter progress claims against, and like if they don't have it in there, you can't really necessarily bill it, or they don't recognize it. So I guess what do you see that process looking like?
So essentially, let's say contract is entered into dated January 1, 2026, which means annual release of holdback is going to occur January 1, 2027. The notice has to go out, sorry, remind me again.
Within 14 days of the,
Okay. So,
14 days of the annual holdback release trigger date.
so within 14 days of that January 1, 2027 date, that notice goes out. Holdback will be based on what the value of the contract is, in terms of value of what's completed up until January 1, 2027. So if the value of the contract is $1 million at that point, your holdback is going to be $100,000, and whether you've invoiced it or you invoice something different, the owner has to release that $100,000 those liens, and then that'll be flowed down to the subs from there in terms of 14 days and 14 days. So once that notice of release of holdback is published, then it's the 16th, it's the first day, it's the fourth day, and then so on. So should you invoice? Yes. It shouldn't be dictated by the invoice because the holdback provisions have nothing to do with submission of an invoice, as opposed to contract dollars, which is very much dictated by profit hours.
I think we're time, but I know I'll be here most of the day. I think you'll probably be
I'm
here
going
most
to
of
hang
the
around a
day.
little bit this morning. I will be back later this afternoon, so if you do have questions, I'm happy to answer them.
There's other lawyers circulating too, we're infiltrating, so.
Would your slides be at all available to examine
We can certainly make them available. I'll have to clean mine up a
Yeah.
little bit, but we can certainly give you to the OCA and district relates to and
Yeah, maybe they're gonna have a bank or a different.
Yeah.
Great, well, we set the hour.